Good afternoon, everyone. We welcome you again to this afternoon's Gender Forum on the Anti-Sexual Harassment Act, UP's rules and procedures. Before we proceed, allow me to call on Professor Fina Flor Thailan, our Program Development Associate for the UPOU Committee on Gender Concerns, to give us a short recap of the events of this morning.
Okay, good afternoon. For everyone's information, we are still web streamed via UPOU networks. .net. You can also view it or look for it in the YouTube if some technical difficulties are encountered in the UPOU networks. Okay, kanina umaga, no, we discussed the basic concepts, basic terms related to gender sensitivity. We said that when we say gender sensitivity, these are activities or the ability of people to identify, recognize gender issues, especially issues and concerns related to women, hopefully towards gender equality and gender mainstreaming in our own offices and programs. So we tackled some tools of analysis so that we could be able to identify some gender issues like activity profile, which you can do in your own offices or kahit sa inyong sariling buhay. No? And then we also discussed or identified some factors in relation to the factors or some socialization aspects in our lives which reinforce or promoted some gender concerns which can lead to gender discrimination, gender stereotypes, and gender discrimination and subordination. So some socio-cultural aspects discussed were the role of media, the role of our family, especially in child rearing, gender and development in school, especially in the curriculum, and also gender and development in the workplace. In those areas, we discussed some examples of practices and situations wherein gender issues were exemplified. Yung mga binanggit nating ano kanina, especially we focus on the use of gender fair language with the hope of really integrating it in yung ating everyday life and especially sa work natin. So ngayon, no, ngayong hapon tamang-tama because one very particular issue na dapat tayo ay concerned lahat, lalo na sa opisina at sa paaralan bilang isang universidad ay sexual harassment. And we have really a law which discusses the things that we need to do, some mechanisms that we need to do in order to prevent or manage sexual harassment concerns. Kaya ibibigay ko na kay Fides yung mic para i-introduce ang ating mga speakers for this afternoon, which we are very lucky to have. So thank you so much.
Thank you very much, Professor Thailan. I'll not let you wait any longer. Allow me to introduce our first speaker for this afternoon. She studied her Bachelor of Laws from the University of the Philippines College of Law and graduated 5th in her class. She has served as Vice President for Legal for Ramon S. Ang, currently the President and COO of San Miguel Corp. And his group of companies, including Far East Cement Corporation, among many. She has also served as legal counsel for Senator Juan M. Flavier, Far East Bank, and even ABS-CBN Broadcasting Corporation. So we are indeed very, very lucky to have our speaker this afternoon. So without further ado, let us welcome Attorney Rowena S. Dicini.
Magandang hapon. All right. So our topic for this afternoon is the Anti-Sexual Harassment Act of 1995. Actually, ang nakalagay dun sa program nyo, it's the UP rules, no, on anti-sexual harassment. But we can't discuss that unless we go all the way back to the Republic Act itself. And that Republic Act actually is based on several policies, no. The first one being from the 1987 Philippine Constitution, it's really anti-sexual harassment is really pinanganak yan ng human rights, no? Diyan galing yan, no? We have a provision in the Philippine Constitution that provides that the state values the dignity of every human person and guarantees full respect for human rights. Also, the United Nations had a Vienna Declaration sometime 1993. They called it the Vienna Declaration and Program of Action of the World Conference on Human Rights. It stresses that all forms of sexual harassment are incompatible with the dignity and worth of the human person and must be eliminated by legal measures and through national action. After that, actually, nagkaroon pa ng isang Beijing Declaration and Platform for Action, but that's around 1995. But before that happened, we already passed the Republic Act number 7877, which is our Anti-Sexual Harassment Act. No? Nevertheless, the Beijing Declaration and Platform for Action, which was held around September 1995, mandates governments to enact and reinforce penal, civil, labor, and administrative sanctions in domestic legislation to punish and redress violence against women, including sexual harassment, and develop programs and procedures to eliminate sexual harassment and other forms of violence against women in all educational institutions, workplaces, and elsewhere. So it's specific yung directive, no, dito sa Beijing program and platform, declaration of program and platform. Nevertheless, as I said, inunahan na natin yan, nagpass na tayo ng Republic Act 7877. To discuss this in detail, I brought my legal assistant. She is Ms. Ophelia Leaño. She's a senior student in the UP College of Law. Hopefully in a year or so, attorney na rin siya. And she's working for our law office also as our legal assistant. I'd like to welcome Ms. Ophelia Leaño to discuss the details. First, no, kasi ano yan, tatlong bodies of law yan, no, or rules. The first is the Republic Act itself, and then the Civil Service also came out with its own rules. And then UP came out with our specific rules as mandated under the Act. So let's welcome Ms. Ophelia to discuss the details. Thank you.
Hello, good afternoon, everybody. As already mentioned by Attorney Dicini, we are going to tackle three actually rules and regulations that govern or our anti-sexual harassment law and rules and regulations, not only here in the university, but also the statute, which is the basis of our rules and regulations. Now we have Republic Act 7877, which is the basic statute. And then we have CSC, the resolution of the Civil Service Commission, and of course UP's own rules and regulations in relation to its anti-sexual harassment, or from the basic or substantive rules and regulation up to the procedure. So this my talk, or this talk today, would be divided into two. We will start with this one, part one, the RA 7877 and the CSC resolution. And then we will be having part two, which is the UP's own rules and regulations. So first, we'll start with the Republic Act 7877. So this is going to be the outline of the whole presentation. First, we are going to discuss a little introduction on sexual harassment, the policy behind the Republic Act 7877, how it is committed, or how sexual harassment is committed under the same statute. Then we have the duties of the employer or the head of office, the liabilities behind the acts, and of course the remedies for those who are victims of sexual harassment. And then afterwards, we are going to discuss CSC Resolution 01-0940, wherein the Civil Service Commission came up with its own definition, how it is committed, the persons liable, the forms, classification, administrative liabilities in relation to sexual harassment. Now, first, I would like to note that it is very important to discuss the CSE resolution. Now, why is that? There are certain differences with the Republic Act 7877, which we will find out later. How different it is the CSE resolution from the Republic Act. And of course, noting these differences, we would already know that there are certain acts that would be covered by the CSE resolution, but not by the Republic Act itself. So first, Republic Act 7877 became effective in 1995. And it is actually the first in Asia. So we were the first country to enact our own statute in relation to anti-sexual harassment. So what is sexual harassment? The Supreme Court in its decision in PAAUC versus NLRC and Domingo versus Rayala stated that sexual harassment is an imposition of misplaced superiority. To note is the phrase imposition of misplaced superiority. From this alone, we can already say that the Republic Act 7877 or the Supreme Court, as it sees sexual harassment, must involve a superiority on some certain level. In addition to that, what is the result? The result, according to them, it must be enough to dampen an employee's spirit and her capacity for advancement, affects her sense of judgment, and changes her life. Which means that basically what this teaches us from the definition or from this pronouncement by the Supreme Court itself, we already have two factors. First, there must be a misplaced superiority, and second, the effects, which is to dampen an employee's spirit and the capacity for advancement. Now we would go on to Republic Act 7877. What is the policy behind this? Section 3 of Republic Act 7877 enumerates the different or the declaration of policy of the state in relation to the said statute. It enumerates 4, which starts with the value of dignity of an individual. As stated earlier by Attorney Dicini, we are taking into consideration the provisions of our 1987 Constitution in relation to valuing the dignity of an individual. In addition to that, the development of human resources. If you can remember, the statement made by the Supreme Court included the advancement of an employee. Now, that is the reason why the declaration of policy, or maybe, in fact, the reason for the pronouncement of the Supreme Court was, in fact, that one of the policies behind the Republic Act is the development of human resources. Now, the third thing is the full respect for human rights, as already mentioned again. It is in relation to the 1987 Constitution. And of course, uphold the dignity of workers, the employees, the students, or those undergoing training. From this section, from the last part, we can already see that the Anti-Sexual Harassment Act of 1995 is focused on two kinds of environments. First, we have workers and employees, which means the environment is work-related. And the second is that for students or those undergoing training, which means it is education-related. So we have work-related environment and education or training-related environment. First, we are going to discuss the work-related environment. Although, admittedly, there are not much difference between acts or how anti-sexual sexual harassment is committed in work-related environment and education or training-related environment, there are still certain differences. So we'll start with what is a work-related sexual harassment. First, a work-related sexual harassment is committed by an employee, a manager, a supervisor, an agent of the employer, or any other person, and I specifically notice, having authority, influence, or moral ascendancy. Remember, we have from our definition of sexual harassment, which is the pronouncement by the Supreme Court, we have superiority, which means that there is a need to have authority, influence, or moral ascendancy in this case. If not, then we cannot be, or the act cannot be considered as an act which is work-related sexual harassment. In addition to that, it is stated that we have the specific acts. We have demands, requests, or otherwise requires any sexual favor. Um, so we have two things, the acts. We have demands, request, sexual favor, and then we have the type of person who can commit such an act, which is a person who has authority, influence, or moral ascendancy. The Republic Act 7877 also enumerated certain acts. Um, First, we have sexual favor is made, and another, the refusal to grant sexual favor. Now, when sexual favor is made, we have this, the 7877 outlined if it is made as a condition in the hiring or in the employment. So if in case that the sexual favor is made not for those purposes, then it cannot be considered as a work-related sexual harassment. On the other hand, what if it is not made or if it is refused? 7877 also provided for that, wherein it states that the refusal to grant must result in limiting, segregating, or classifying the employee which would discriminate, deprive, or diminish the employment opportunities. Now a question is raised. Is that the only thing, or in that specific context, is sexual harassment committed solely on the basis of those two acts? The answer to that is no. We have two other acts which is enumerated. We have if the acts would impair the employee's rights or privileges under existing labor laws, and another if it would result in an intimidating, hostile, or offensive environment. What does this mean? It means that although sexual favor is made, or you refuse to grant sexual favor, if for as long as certain the demands, the requests for sexual favors resulted in the intimidating, hostile, or offensive environment, then it may be considered as a sexual harassment act. If I'm not mistaken, way back, I have heard certain things like, sexual harassment yan pag feeling mo naharas ka. If I'm not mistaken, or I personally believe that that phrase would be considered in relation to number 3. Now, if you are already feeling, or the environment has already has already become intimidating to you, hostile or offensive, then that in itself is a ground to be considered the demand or the request as sexual harassment. Next, as I have said or mentioned before, there is not much difference with work-related and education or training-related sexual harassment. As you can see, it's basically the same thing, this time just committed by teacher, instructor, professor, coach or trainer, or which basically means that the person must have authority, influence, or moral ascendancy. And of course, there must be a demand or request for any sexual favor. Now, what is the difference? The difference between a work-related and sexual work-related sexual harassment versus education or training, training-related sexual harassment is on the enumerated acts. Here, in an education or training environment, sexual harassment is committed against one who is under the care, custody, or supervision of the offender. If you can remember, under work-related, there are specific conditions. However, this time, it states merely that sexual harassment is committed against a person who is under the care, custody, or supervision of the offender. Next, against one whose education, training, apprenticeship, or tutorship is entrusted to the offender. Probably this is because of the moral ascendancy that a trainer or a professor or a teacher has over his or her students. Next, now this time, this is the condition. We have a condition, sexual favor is made as a condition to the giving of a passing grade or granting of honors. This is akin to the statement under work-related sexual harassment before, wherein sexual favor is made in relation to the employment or for the hiring of a person. So this is akin to that statement. Next, this is similar to number 3, which means that it must result in intimidating, hostile, or offensive environment for the student, trainee, or apprentice. As you can see, there is not much difference between work-related and education or training-related environment sexual harassment, as I have already stated earlier. So next, we have the duties of the employer. We have duties in general and the specific duties. This is important because this is going to be the basis of the issuance of the UP's own rules and regulations, which we'll be discussing afterwards. Now, Section 4 actually provided for the different duties of an employer or head of office in relation to sexual harassment. We have 2 general duties. We have to prevent or deter the commission of the acts of sexual harassment, and the second is to provide the procedures for the resolution, settlement, or prosecution of the acts. So we have the first part, we have to prevent or deter the commission of the acts. The second would be the remedies that is going to be available to the victims of the Sexual Harassment Act. Now, the RA 7877 also provided for certain specific duties of the employer. We have 2. First, we have to promulgate the rules and regulations, which must include the proper decorum. And the second is the creation of the committee on decorum and investigation in cases of sexual harassment. As you can see, this is related to the general duties of the employer in relation to sexual harassment. Now, in relation to the promulgation, first we have the promulgation of rules and regulations. Under the Republic Act 7877, there are 2 requirements. First, there must be a consultation, and second, there must be joint approval. When you say joint approval, it must be approved also by the employees or the students or apprentices, in this case, for education-related environment. Also, there are 3 things that the rules and regulations must provide. First, the provision for the procedure for the investigation of cases. Second, they must provide administrative sanctions. And third is the guidelines on proper decorum. So we can say that the rules and regulations of the university is complete once it satisfies the provision of RA 7877 in relation to the rules and regulations that must be issued or enacted by the university. Now, we have a note here. 7877 also provides that the administrative sanction shall not bar the prosecution of proper courts for unlawful acts of sexual harassment. What does this mean? It means that even though administrative sanctions have already been imposed on a person after being found out guilty of a sexual harassment act, he or she may still be prosecuted under our courts or under the courts of the Philippines in relation to the unlawful acts of sexual harassment under this specific statute. It means that administrative sanction will not deter, or it will not provide a person, it will not deter a person from filing a criminal action against a specific person who committed such an act. Now, although 7877 provided that the committees on proper decorum may be created by the administrative authority, they specifically provided that there must be a composition. For work-related, there must be at least 1 representative from the management, from the union, if any, from the representative from the employees from the supervisory rank, and employees from the rank and file. So, although, as already stated, the creation of the committee is a duty of the employer, which was mandated under 7877, the 7877 itself requires that the composition of the committee must be at least these 4 people representative from different ranks in relation to work-related environment. On the other hand, for those under education or training related, we have three. We have at least one representative from the administration, from the trainers, teachers, instructors, professors, or coaches, and another representative for students or trainees. Now, what are the tasks? 7877 also provided specific tasks for the Committee on Decorum and Investigation of Cases. First, they must conduct meetings with other offices and employees to increase understanding and prevent incidents of sexual harassments. And second, the conduct of the investigation of alleged cases which constitutes sexual harassment. As you may see, the name Committee on Decorum and Investigation of Cases is actually divided into these two specific tasks for the committee. The first one relates to the decorum, the second one is for the investigation. Now, what are the liabilities? Of course, if there is an unlawful sexual harassment act, there must be a liability, or else this would not have worked. We have, first, although it did not directly commit the sexual harassment act, the head of the employer, the head of office of the educational or training institution may still be liable under Republic Act 7877. Now, what is its liability? It is solidarily liable for damages, which means that a case may be filed against the head of office or the employer, and it would be solidarily liable. When you say solidarily liable, you may be liable for the full amount of the damages that the courts would require the specific offender to pay the victim. Now, in this case, when will the head of office or the employer be held liable? It will be held liable if there is no immediate action taken when it was informed that such acts or sexual harassment acts has been committed by the offender. So when will the liability arise? It is simple as this. If the offended party reported a sexual harassment act to the employer or the head of office of the training or educational institution, it must have an immediate action. Without an immediate action, it may be held liable, solidarily liable in fact, with the offender for damages that would arise from such sexual harassment acts. Now, although there is no period of time, yes. Although there is no specific period given under 7877, we will see that the Civil Service Commission actually provided for a period of time when such action must be taken by the disciplining authority or by the committee or by the sexual harassment office, which we will learn later on, in relation to cases involving sexual harassment. So what are the remedies of the offended party? We have three. We have administrative, we have civil liabilities, and we have criminal liabilities. First, now the administrative sanction, if you can remember, the administrative sanction is imposed by the disciplining authority. In this case, if you talk about the University of the Philippines, we have the University of the Philippines rules and regulations in relation to sexual harassment. So the UP or UP can impose administrative sanctions. Later we will discuss what these administrative sanctions are against the offender, which would be independent from the civil or criminal action under this specific statute. So we have here Section 6. This provided for the civil action in relation to sexual harassment acts that are committed. So we have the independent action for damages. Section 6 specifically states that the administrative sanction or the imposition of the administrative sanction, it will not preclude the victim from filing an independent civil action, this time civil. We have a few slides earlier, we have criminal action. This time, an independent civil action for damages and other affirmative relief. Section 7, on the other hand, provided for criminal liabilities for violation of RA 7877. What are these penalties? We have actually we have two kinds of penalties. We have imprisonment, which can range from 1 month to 6 months, and a fine of 10,000 to 20,000. Now, question: May the court impose both fine and imprisonment? The answer to that is yes. It would be, however, left to the discretion of the court. So after discussing, that is actually the overview of Republic Act 7877. We are now going to discuss CSC Resolution 010940 in relation to sexual harassment acts committed and their jurisdiction over the same, the substantive laws regarding that, and its difference. There are actually differences from RA 7877 and this CSC resolution. So like our discussion of RA 7877, we also divided this into first, how do you define sexual harassment, how it is committed, the persons who are liable, the forms and classification which they actually have in the CSC resolution, which we don't have in RA 7877, and the administrative liabilities for such sexual harassment acts. First, as you can see, Section 3 on the Rule 3 of the CSC resolution, there is a definition, and it was they did not actually define sexual harassment act per se. What they defined is the administrative offense of sexual harassment. It is defined as an act or series of acts. What does it involve? First, sexual advance, request, or demand. Not really that different from RA 7877. For a sexual favor or other verbal or physical behavior of a sexual nature. This time, may see that it seems to clarify that any kind of verbal or physical behavior, for as long as it is sexual in nature, may be considered as an administrative offense of sexual harassment. Now, we have an enumeration of circumstances when sexual harassment is committed. Like in RA 7877, there is also an enumeration which provided for the work-related environment sexual harassment. First, we have the submission to or rejection as a basis for any employment decision. This is not actually very different from RA 7877's version of sexual favor is made in relation to employment. Second, the purpose or effect of interfering with the complainant's work performance, or, as you can see, intimidating, hostile, or offensive work environment, which is also similar to RA 7877. However, there is an additional here, wherein the acts might reasonably be expected to cause discrimination, which means that for as long as an act may cause discrimination, insecurity, discomfort, offense, or humiliation to a complainant, this time we note, who may be a co-employee, an applicant, customer, or ward of the person complained of, it may already be considered as an administrative offense of sexual harassment. Now, we have to take note of this because if you remember, RA 7877 specifically provided that there must be authority or moral ascendancy. On the other hand, this specifically stated that it may be a co-employee, not necessarily a manager or a supervisor or a person with higher rank. That for as long as there are just the condition is for as long as it may cause discrimination, insecurity, discomfort, offense, or humiliation. What about training, education, or training related? This is actually basically the same thing. Now, this time, just the basis for any decision affecting the complainant. Same intimidating, hostile, or offensive academic environment this time. And then, same result. for the complainant who may be a trainee, apprentice, intern, duty, or ward. So basically, almost the same enumeration, just of course different people who are involved in the acts. Another difference with RA 7877, Rule 3, Section 4 of the CSC resolution specifically provided where sexual harassment may take place. First, it may take place in the premises of the institution or of the office. Second, in any place where the parties were found as a result of, and we take note of this, work or education or training responsibilities. Which means that if they are in a specific place, not necessarily in the premises, for as long as the reason for being there is work or education or training related, then sexual harassment, the administrative offense of sexual harassment, as provided under the CSC resolution, may take place. Third, social functions, which must also be related to work, education, or training. Fourth, if they are on official business. Fifth, at official conferences, fora, symposia, or training sessions. And lastly, it may take place by phone, telephone, cellular phone, fax machine, or electronic mail. This basically means that if someone sent you an email and you feel harassed, that may be considered a sexual harassment act under the CSC resolution. So the CSC resolution actually, yes. Although, of course, we have to note that the same must be related or work-related or education or training-related. Now, CSC resolution also provided the kind of persons who may be liable under this. If you read RA 7877, we do not have the same kind of enumeration in that statute. However, the CSC resolution specifically provided who may be liable for the said acts. First, those who are liable for direct participation or the person who actually committed, who directly committed the said act. Second, if a person induced another to commit the same act, the person who induced or directed the offender may also be liable under CSC resolution. Third, if you cooperated in the commission of the act through an act without which the act would not have been accomplished, which basically means that your participation is needed for the completion of the act. It means that even though you did not directly participated, if you were cooperated with the offender in committing the same act, and without which he or she could not have completed the said act, then you may also be held liable. And lastly, if you cooperated in the commission of the act through previous or simultaneous acts. This is actually akin to the different persons who are liable under the revised penal code.
Both the act, so both in the act and in the civil service, it's mentioned. Siguro to avoid any confusion, no? Kasi ang dami, meron kayong RA, the Republic Act, then there's the Civil Service Resolution, and then later we'll discuss the UP rules. No? To make sense of it, I think if it's administrative, you want to file an administrative case of sexual harassment, meaning you want your boss, for instance, who harassed you, to lose his job. No? Then I think the rules that you should follow should be the civil service rules, right? But if you want to sue him criminally or sue him civilly for damages, I think the rules that should be followed should be the Republic Act. Why? Because yung civil service, nagdagdag siya eh. Kagaya niyan, yung co-employees, ganyan, which were not originally in the Republic Act itself. And if you sue someone criminally, you deprive him of his liberty. Ang rule kasi sa revised penal code, dapat, if there's no law that punishes that act or making it criminal, then there's no crime. So if you base your criminal complaint on the provision of the civil service, it might be dismissed. Kasi hindi siya, so, pwede kong sabihin, wala pa naman yatang case na ganyan, we have not come upon a case like that. But kung ako yung sinusue for sexual harassment, sabihin ko hindi yan crime wala naman yan sa RA 78, 77. I'm bad with numbers. So, yun yung main difference, no? So, pagka nalito ka, gusto ko tong ikulong o doon ka sa RA, doon sa Republic Act. Gusto ko lang itong mawalan ng trabaho, masuspend or whatever. Then, short of him being criminally liable, he might be administratively liable. So you can use the rules of the civil service. So that's how it interacts. Go ahead, sorry.
The CSC resolution also provided for the forms of sexual harassment. We have the physical, verbal, the use of objects, picture or graphics, letters or writing notes, and other analogous to the foregoing. This is also provided specifically under the CSC resolution. And if you will notice, we don't have this classification or forms under RA 7877. Next, we have the classifications. What are classified as grave offenses? Now, this is important because the classification would tell you what penalty is imposed to a specific act. For grave offenses, we have 5. So if there's an unwanted touching of private parts, that's already a grave offense. Sexual assault, malicious touching, requesting for sexual for in exchange for privileges and other analogous cases. For less grave offenses, this time, not a private part, but against a victim's body is enough for a less grave offense. If pinching, if it does not fall under a grave offense, then it is a less grave offense. Now, derogatory degrading remarks or innuendos are already part or considered as a sexual harassment act, which is a less grave offense. Verbal abuse and other cases analogous to the aforementioned. Lastly, we have the longest enumeration. We have the light offenses. So surreptitiously looking at and staring at you is already enough to be considered as a light offense. Telling sexist or smutty jokes is already enough to be considered as a sexual harassment act under the CSC resolution. We have malicious leering or ogling and display of sexually offensive pictures, materials, or graffiti. Not only that, we also have other cases. Unwelcome inquiries about the person's sex life, unwelcome sexual flirtation, advances, and propositions, making offensive hand or body gestures, persistent unwanted attention, unwelcome phone calls with sexual overtones, and cases which are analogous to this. So, if we read this specific acts or the classification of acts of sexual harassment, we can already see that the CSC resolution covers a broad or a large number of acts. That they already specifically provided that these certain acts are prohibited or are considered as a sexual harassment act. Next, what are the administrative liabilities? For grave offenses, the first offense in already may cause the dismissal of the offender. However, for less grave offenses, the first offense would mean a fine or suspension, but the suspension is greater than 30 days. However, for light offenses, it's only reprimand. As you can see, of course, this is graduated from first offense, second offense, and third offense. The second offense of our less grave offense can cause the dismissal of the person, while the light offense only for fine or suspension, this time from greater than 30 days to less than 6 months. Then a third offense, even though it is a light offense, may cause the dismissal of the offender. Next, now what if you are found guilty of 2 or more charges? Under the CSC resolution, it is stated that the imposable penalty with is that which corresponds to the most serious charge or count, which means if there's a light offense and a less grave offense, that which is we take into consideration the most serious charge or count, which in this case, the less grave offense. And then the rest will be considered as an aggravating circumstance. Now, as I have already told you earlier, under RA 7877, it only stated that the head of office would have a liability if there is no immediate action, but no specific period was stated. In this case, under Rule 11 of Administrative Liabilities under CSC Resolution, it specifically provided that the head of office must act within 15 days from receipt of any complaint properly filed. Otherwise, the said head of office may be charged with neglect of duty. So that would conclude the first part from RA 7877 to the CSC resolution. We would now go to the UP's rules and regulations.
Okay, I'll just interfere first. No, hindi pa tapos kasi we have to discuss the UP rules. But just to clarify certain, because we discussed two, the Republic Act and the Civil Service Resolution. Ophelia already pointed out the differences, no? And as I said, these differences will matter depending on ano ba ifa-file nyo. Fa-filean mo ba siya ng criminal, fa-filean mo ba siya ng administrative. So, I think you've covered all of it. Ang importante would be, note no, that the Civil Service Resolution covers state colleges and universities, including government-owned and controlled corporations, so with original charters. So that includes us. So that will include UP. So although we have our own rules, still, our rules, as I said, should not waive anything that is provided for in the Civil Service Resolution. So pwedeng meron tayong own rules, it can only be stricter, no, but not less strict than the Civil Service rules. So ang mga dinagdag niya has been already discussed by, dinagdag ng CSC resolution has been discussed by Ophelia. Let me just point out certain important provisions. No? For me, ang importante doon, yung sexual harassment may take place. Wala yun dun sa original Republic Act, but in the Civil Service Resolution, specify niya kung saan lang pwede. Which means kung hindi doon, walang sexual harassment. Parang ganon. But we're talking about administrative. The fact that the Republic Act did not specify where means it didn't care. Kahit na nasan yan, basta somebody committed an act of sexual harassment as defined under the Republic Act, then merong sexual harassment. But in the Civil Service Resolution, they specified the places in the premises of the workplace, any place where the parties were found as a result of work, at work or education or training related social functions, when you're on official business, official conferences, or by telephone, cellular phone, fax machine, or electronic mail. I think ito, using, hindi ba dapat to using the office's telephone, cellular, fax machine, or electronic mail? Pero hindi naman sinabi dito. Pero so siguro, we can interpret this to mean na kung meron kang kaopisina, nag-email galing sa bahay ng mga sexually harassing pictures, may mga connotations that is that sexual harassment? I guess in this case, dahil hindi niya naman specify na dapat with the use of office, diba? Pwede siyang maging administratively liable. The problem with these provisions, they're untested. So they only become clear when cases arise. So which brings me to my So kukwentuhan ko kayo ng konti para hindi kayo antukin. Ayan. So merong kaso na Siyempre, gusto nyo maramang mga sexual harassment na cases, di ba? Example, sige, kuha tayo ng isa. Let's get one example where it is employment-related sexual harassment. No? This is the case of Formantes versus Duncan. Duncan is a pharmaceutical company. Meron silang manager, district manager, pangalan niya si Ramon Formantes. Under him, meron siyang medrep. Di ba magaganda yung mga medrep na yan? Oh. So pangalan niya si Cynthia Magat. So ano nangyari sa kanila? Actually, this is a case that was brought to the Supreme Court as a labor case kasi nagreklamo tong si Ramon Formantes na in-illegal dismissal siya. Terminate siya. Well, he said it was, anong dismissal yun? Constructively dismissed. Bakit? Kasi pinapa-resign siya, ayaw niya mag-resign. So, ginawa, hindi siya pinapa-attend ng meetings, hindi siya binibigyan ng trabaho, hindi siya binigyan ng mga medrep under him, ganyan. So, parang constructively dismissed siya. Nag-file siya ng constructive dismissal case against the company of Duncan. Itong Duncan, I think, no, natalo yata sila. But eventually, upon appeal, they, during the course of the exchange in evidence, presentation of evidence, pinresent nila yung evidence na ito palang si Ramon Formantes nag-sexually harass ng isa niyang medrep. Okay, paano nangyari? Yan. Ako, parang, there were 3 incidents. So, sa akin parang, bakit mo papaabuti ng 3? Anyway, yung first incident involved Formantes with his medrep meeting in the place of the medrep, the girl, si Magat, yung babae. Nag-meeting sila dun sa apartment niya. Tung si Formantes, sabi niya, oh, akit tayo dun sa taas, na dun yung kwarto niya. Ito namang si Magat, sabi niya, hindi, dito na lang tayo sa baba. Boss niya kasi, yung guy. I don't know why they proceeded to meet in the apartment in the first place. It was not, hindi nakasabi dun sa sworn statement ni Magat. But anyway, ito sabi niya, umakyat pa rin yung lalaki. So sinundan niya sa kwarto niya, no, sa taas. So sabi daw ng lalaki sa kanya, hinawakan yung kamay niya. At ang sabi, Cheng siguro yung kanyang nickname, na-excite ako sa'yo. Ayan. Tapos, sabi niya, wag kayong ganyan, baba tayo. So, bumaba sila. Pero later on, umakyat na naman yung guy. So, sinundan na naman niya. This time, nakakamiseta na lang yung lalaki. Nagupad na ng, ang tawag dyan, ng barong or whatever, Tapos, itong si Magat, lumabas bumili ng Coke. Hindi ko alam bakit. Basta lumabas siya, bumili siyang Coke. Pagbalik niya, inakap na siya ni Formantes, and he pulled her down to the bed. Tapos sinasabi na, namimiss lang kita at ang barkada natin, palambing naman. Ayan, yung kanyang words. And then, he pinned her down the bed, got on top of her, and asked for a kiss. Ganyan, nire-resist naman ng babae. And then, according to her, the Formantes said, I am your boss. Ganyan. And then, he tried to kiss her, squeezed her buttocks, ganyan, no? Held her jaw and started putting his tongue in her mouth. Oh, may mga bata ba dyan? Baka naman. So, after that, she finally got away from him. And nagsorry naman yung boss, pero hindi niya ni-report. Meron pa kasing naging second incident, pero dito hindi naman ganun kagrabe yung nangyari. Parang he just made sexual advances to her. He visited her apartment, but the boyfriend was there, so naun siya me. Third incident naman, kumatok na naman siya dun sa apartment, hindi na niya pinapasok. So yun yung narration ng babae. Ang sabi ng court, dito in the end, oy, tama na terminate ka kasi ikaw sexual harasser ka. Ewan ko kung tama to, pero sa akin, legally medyo, do you think so? Do you agree? Legally, parang yung pagka-terminate nitong ni Formantes mali. Pero ito yung sinabi nila in relation to, but we're not here to discuss labor law. We're here to discuss the issues on sexual harassment. And this is what the court said. Aside from self-serving testimony, Fermantes, yung lalaki, was not able to sufficiently contradict this charge of sexual abuse. Moreover, the courts usually give credence to the testimony of a woman who is a victim of sexual assault because normally no woman would be willing to undergo the humiliation of a public trial to testify on the details of her ordeal if it be not to condemn an injustice. So they still hold that Neanderthal belief na ang mga babae ay hindi lang magsha-shout na I'm raped kung hindi talaga siya ni-rape. We know now that there are certain instances na hindi ganon. Pero anyway, yun pa rin yung pag-iisip ng court. No? And because of that, because of the introduction of the sexual harassment incident, no, the court said there's justifiable ground for the dismissal for lack of trust and confidence nitong so natalo si Fermantes. So that's an example of a sexual harassment in the workplace. I think it will be under yung superiority, di ba? May boss ka niya, so he holds a position of influence. So yon. It also, meron ding mga ibang cases where sige. Itong isa naman sa training related or educational, itong case na to, si Baksin. So, merong sa Baksin, isang elementary school to, hindi sinabi. Anyway, there's a student, no, in elementary school. Elementary, oo, so bata pa. Yung father yung nag-file, no, in behalf of the minor, and they claim that yung estudyante who's unnamed, no? Let's say si Ophelia, ayan. An elementary student, no? He was asked to go to the office of his teacher of Professor Baksin, no? And once inside, she saw him get a folder. He placed it on top of a table and he called Ophelia, come here, come closer. Called her. And then when she did, he held her hand and then touched and fondled her breasts. Bata pa to, no? May nakakitang classmate, kaya na-witness, no, yung incident. And that classmate testified afterwards. That became the basis for the complaint of the father. In this case, tama naman na si Baksin was guilty of grave misconduct and committed an act of constituting sexual harassment. Yun ang sabi ng Civil Service Commission. Di ko na i-discuss kung ano pa yung final kasi masalimuot siya. But ang sinabi lang dito, ang importante on sexual harassment, no, is the formal charge kasi kay Baksin, hindi nila minention yung RA 7877. Sinabi lang nila yung act. And then they said, dapat grave misconduct yan, i-dismiss yan for grave misconduct. So, but he was nevertheless penalized under 7877, even if this was not specifically mentioned in the complaint of the father. The reason being, sabi nila, no, the court said, the formal charge, while not specifically mentioning R8 7877, imputes acts covered and penalized by the said law. The demand of sexual favor need not be explicit or stated. Wala nga demand of sexual favor. Even without an explicit demand from Baksin, his act of mashing the breast of the student is sufficient to constitute sexual harassment. Because it was committed because it resulted in an intimidating, di ba yung kanina, hostile or offensive environment for the student. Why am I telling you this case? There's a lot pa, pero let's just for the, so we save time, I won't discuss the rest. But I think if you read the cases on sexual harassment, those that at least went all the way up to the Supreme Court, you'll see na medyo partial ang Supreme Court in passing judgment against the offenders. And that's why I think it's important na when we are faced with cases like this, no, we don't just, ang hirap kasi ang dali. Pag nakita nyo, di ba, parang even the light offenses, there's just so many, mag-joke ka lang, mag-sexual joke ka lang, I think is already a sexual harassment. Kunyari, yung katabi mo si Mike, tabi mo sa opisina, mag-joke ka ng merong sexual undertones doon, pwede ka niyang sampahan. Pwede kang masuspend at the very least. There's a suspension that's the penalty of suspension if it's not dismissal. Masususpend ka at the very least. No? Ang ano ko dyan is that we should be very careful, especially those, and I'm not sure what hindi ko alam kasi hindi ko pa naaral yung mga sexual harassment cases na dumaan sa OWASH sa atin wala pa. Okay. Sa Diliman, meron, marami. Pero nobody has made a determination if the policy is really towards against the offenders. Kung may kampi ba tayo, mas kampi tayo sa ganun. What this shows is that the Supreme Court mas kampi siya doon sa pinapunish na yung offenders. Given this, I think it's very dangerous. Ako nakikita ko kasi it can be easily misused or abused. And that's why not all cases, even if merong magreklamo dyan na estudyante, we should always try, especially sa gender, I think the gender committee is also the committee for sexual harassment. So if ever complaints are filed in the meantime, the complaints are filed, no, kung meron man, sa inyo pupunta. So dapat yan, it has to be studied, no? It has to be objectively evaluated before you pursue anything. Kasi nga, it can be used and abused, no? Either way. All right. So Ophelia will discuss the specific rules of UP. How does that operate now? So as I said, if the Republic Act, that's what you use if you want to file a criminal case or a case for civil damages. But if you want administrative, you follow the civil service rules. And I think the UP rules also. I think the UP rules do not, correct me, no, mas naaral ni Ophelia yan. Hindi yata naman kinurtail ng UP yung provisions ng civil service. Nag-add lang siya. Certain definitions, he made clearer, like what is a student, no, who are covered and all that, no. May mga saan ba yun? Hindi ko dala. May mga differences, pero I don't think it waived any provisions or changed it in such a way that the rights and interests of both parties are prejudiced. So, pero we need to look at the rules of UP para malaman natin, kasi that specifically applies to us, along with the civil service. Yan. So with that, let's look at the UP rules. Siguro you can discuss the main differences na lang because there are very similar provisions anyway.
Okay. So now we are going to discuss the rules and regulations of the University of the Philippines in relation to the Sexual or the Anti-Sexual Harassment Act. Basically, the same type of outline that we have earlier, what is sexual harassment, how it is committed, and we will see kung gaano siya kasimilar or different from RA 7877 in the CSC resolution. Pero feeling ko, more on interest natin dito is the procedure kapag what happens if there is a sexual harassment act. Ano yung gagawin natin or what is the procedure of the university when it comes to the investigation of these cases? First, we have the policy of the University of the Philippines, which is to establish and maintain an intellectual and moral environment in which the dignity and worth of all members of the academic community are guaranteed full respect. Again, the words dignity and the worth of all the members of the academic community. Second, to provide a secure and conducive learning and working environment. As stated earlier, ito yung we point to Sexual Harassment Act, which results to the offensive and hostile environments. So that is the policy of the university. As Attorney Dicini already stated, the UP's rules and regulations defined what students are, the employee and the faculty member. So the rules and regulations gives a specific definition. For students, they are persons who are duly enrolled for degree course or in short-term training or review program. Mamaya sa policy and standards and guidelines, you will see yung talagang coverage of the rules and regulations. For the employee, those who holds an official appointment, this will include those who are casual or contactual employees, the graduate or student assistants. On the other hand, faculty members are those who are members of the teaching staff, but they also include the librarian, researcher, research associate, the coach, trainer, or of training specialist, extension worker, and the graduate student, for as long as those graduate students have teaching responsibilities. So how does the University of the Philippines Rules and Regulations define sexual harassment? According to the policy standards and guidelines, sexual harassment is a reprehensible conduct which subverts the mission of the university and undermines the careers of students as well as faculty members, as well as those of the research and administrative personnel. So that's how the university defines sexual harassment. So here we have the acts. Section 3A, the definition of the university's rules and regulations is actually almost copied verbatim with RA 7877, the person with having authority, influence, moral ascendancy. This time, in relation to academic or administrative work in the campus. So yun lang yung ina. That's the only things that are added. Basically, same definition when it comes to sexual harassment. This is also the same for the how it is committed for work-related environment. That is basically a word-by-word copy of the RA 7877 Section 3 then actually A. This time, if you can see, there are just, the university just added the privileges of a faculty member. Previously, it was just employee and under existing civil service law rules or regulations. So that is the addition to the previous definition or previous provision that RA 7877 provided. This is also the same for the academic teaching or study environment. Same thing as RA 7877. There are just minor changes. This time against a student, trainee, or one is under, which is basically the same, similar, under the care, custody, or supervision of the offender. Number 2 is also the same, and 3 and 4. Okay, so basically, what we discussed earlier about RA 7877, how sexual harassment act is committed, is the same for UP's rules and regulations. Same with the inducement or cooperation. Those who directs or induces and those who cooperated in the commission of the crime are the persons who are liable under UP's rules and regulations. Now, ito yung, this is the addition to RA 7877. This time, what does UP's rules and regulations cover? It covers officials, faculty members, the employees, students, and we take note even applicants for academic or administrative positions are already included, and applicants for admission as students, provided that the application has already been received. This means that even if the person or is just a would-be student or just a mere applicant, for as long as the application has already been received by the university, if a sexual harassment act is committed against that person, it is already considered as a sexual harassment act as defined under UP's rules and regulations. Now, the cases which is covered, these are for if you may remember, this is not the same with the CSC resolution. We added cases that are covered. First, involving abuse of authority. This has already been covered by 7877 in the CSC resolution. However, we added peer relationships, which means if the relationship between the offender and the offended party is a faculty to faculty, employee to employer, student to student, this would also be covered under the sexual harassment. This would also be considered as a sexual harassment act, even if there is no moral ascendancy in this type of relationship. Third, If there is a harassment of faculty members or employee, this time by students, these are also covered. And those of the same or the opposite sex. So, as you can see, the sex of the offender or the offended party is not a consideration for it to be considered a sexual harassment act. The same with the rank or the position of the offender or the offended party. So regardless of those things, you can still file for, or you can um, file a complaint against the offended party, regardless of the rank or position that you hold, in relation to that offender or the sex of the offender. Now, what are the policies and standards of the university? The sexual harassment is a ground for administrative action. Later, we will see the penalties imposed by the university for the sexual harassment acts that are committed. Now, it's stated that all reported incidents shall be investigated and appropriate action shall be taken by the university, but with the consent of the victim and taking into account the integrity and other preponderant interests of the university. Next, as part of the policy and standard of the university also, the officials, the faculty members, the employees, and the students are actually entrusted with duties to observe confidentiality and to respect individual privacy. Next, the university will provide all possible support services. We will discuss later question na if is it only through a complaint filed with the university, is that the only action that we may take? There are actually what we call the informal procedure, which we will later discuss. And then the last is that retaliation against parties directly or indirectly involved will not be tolerated by the university. It is also a ground for a disciplinary action. Now this, as I was talking about it, what are the procedures? There are actually two. We have the formal and the informal procedure. First, we go to the formal procedure. So when a sexual harassment act is committed against a person, what does that person do? First, he or she can file with the sexual harassment office under oath a complaint with or without supporting affidavits. So that's the first thing. Now, the sexual harassment office would then create a hearing committee if it finds probable cause, which means that if the finding of the sexual harassment office is that this act is possibly committed by the offender against the offended party, then they may create the hearing committee. After the creation of the hearing committee, an answer may be filed by the offended party. Now, the rule is that it must be filed within 72 hours from the receipt. However, such a time may be provided by the hearing committee upon notice. They will give out the notice when the answer should be filed. So it may go beyond the 72 hours. But as a general rule, it should be 72 hours from receipt. The answer must be signed and sworn to. Now, the failure to appear during the hearing of the committee or failure to file an answer is already considered as a waiver of a right of that offender or of that person to introduce evidence in his or her behalf. Then it must indicate whether he elects a formal investigation. Next, we have the hearing. After all the pleadings have been filed, there are specific periods of time that the university provided in this case. We have not earlier than 5 days, not later than 10 days from the receipt of the answer, and it must be concluded 30 days from the filing of the charge. Now, the committee will now then prepare the report within 15 days after the conclusion of the hearing, and the report and the recommendation must be submitted or will be submitted to the sexual harassment office. After note that during the hearing, upon recommendation of the Sexual Harassment Office and the VCAA, the Chancellor, but not more than 90 days, if the charge is grave misconduct, this is specifically for cases that charge grave misconduct, and the evidence of guilt is strong, there may be a preventive suspension against the offender in this case. So note that there are conditions when a preventive suspension may be imposed. First, the charge must be grave misconduct. Second, the evidence of guilt must be strong. And this time, it is recommended by the Sexual Harassment Office and the VCAA, and only the Chancellor may impose the preventive suspension. Now, if what happens if the case has not yet been decided after the 90 day, for example, there's a 90-day, you suspend, there's a preventive suspension for 90 days. What happens when the case has not yet been resolved? There is an automatic reinstatement of that person to his or her post. If the delay is due to the respondent, the number of days shall not be included in the count of 90 days. So if the 90-day delay is due to the respondent in this case, or he or she keeps on delaying and delaying the hearing, then it will not be counted in the 90-day period limitation. Next is the decision. So the Chancellor renders a decision 15 days from receipt of the committee report and recommendation, and it will become final and executory 10 days after the receipt. The appeal, on the other hand, will be filed in accordance with the rules on administrative cases of the university. Now, what is this informal procedure? That is the formal procedure. What do we mean by informal procedure? The informal procedure refers to the university action, this time without a formal investigation or filing of formal charges. Now, this consists of two things. First, we have counseling, and second, we have the providing of information or other means of support. This is also included in the UP's rules and regulations in relation to the sexual harassment. So what is the Sexual Harassment Office? This is the composition of the Sexual Harassment Office. As chairperson, on the rotating basis, we have the VCAA, the VCA, the Vice Chancellor for Student Affairs, and the Chancellor or equivalent officials. Then we have one representative from the faculty, the employees, and the student sectors. Next, we have the Director of the Women's Study Center or chairperson of the Women's Desk of the Chancellor's Office. Then the coordinator of the Sexual Harassment Office, which must be a non-voting member. Now, what are the functions? The functions of the Sexual Harassment Office is enumerated under Section 8B of UP's Rules and Regulations. First, they undertake information and educational activities. Second, they design or formulate the informal procedures because this is not provided for under UP's Rules and Regulations. The Sexual Harassment Office itself actually provides for the informal procedures. Then they provide the security and support measures for the victims, and they constitute the hearing committee if it is required under a formal investigation. As mentioned earlier, the Sexual Harassment Office creates the committee after the finding of a probable cause. Now, what are the penalties? Okay, so the penalties, there are three kinds. We have the grave misconduct, conduct prejudicial to the best interest of the service, and simple misconduct. This is actually similar to the grave offense, less grave offense, and the light offense under the CSC resolution. Same thing with grave this time. Like grave offense, grave misconduct may cause a dismissal of the person upon first offense. On the other hand, if the conduct is prejudicial to the best interest of the service, then it is only a fine or suspension of greater than 30 days, while for simple misconduct, it is only a reprimand. And also, as for second offenses, it may already cause a dismissal if the conduct is prejudicial to the best interest of the service. And if it is only simple misconduct, then a fine or suspension, the suspension will be greater than 30 days, but less than 6 months. And for third offense, for simple misconduct, it may already cause a dismissal of the offender. So that's just about UP's rules and regulations in relation to sexual harassment.
Thank you very much to Attorney Dicini and Ms. Leaño. The floor is now open for your questions or comments about the presentation?
So for example po, attorney and ma'am, di ba kung ang gagamitin yung sa Civil Service Commission, tama po ba ako na just for public government, for government offices lang yun? So, so if it's for private, it's the RA, na? Yeah, for the public, yeah. Oo. So kung yung binabanggit niyo po kung administrative penalties ang gusto, hindi po siya covered ng RA, you said, no? It's more for... meron din...
Um, the RA provided for three kinds of liabilities, as mentioned before: administrative, civil, and criminal.
so meron din naman.
Yes. Technically, it goes like this. The administrative sanctions is provided by the disciplinary authority. This time, in case of the University of the Philippines, it's UP.
Okay.
Then afterwards, you can appeal it to the Civil Service Commission. However, if you file an administrative case against that person, this does not bar you or this does not preclude you from filing a civil or criminal action with RA 7877 as your basis.
Okay. Thank you. Yeah.
Maybe you should use the rules of the civil service if it's a government employee. But it doesn't mean if it's a private employee, walang sexual harassment. Under the RA, yes, nandun siya.
Thank you. Baka may iba pa, may mga iba pa akong tanong pero mamaya na lang. Baka may iba pang gusto magtanong. Well, others are still thinking of their own actions. ano, kanina you mentioned kung ano yung mga pwedeng, ano nga yan, places or, tama ba yun, form, ano nga yung term, kung sa, pwedeng gamit ang electronic mail, text, ganun. Paano kung yung sa case ng OU, core site, o kaya is through Skype, Google Hangout, kasama na ba yun sa electronic mail or iba pa? Or cybercrime will, I'm not sure, sorry. That's another, okay.
If it's an act of sexual harassment and your question is the method is by electronic mail, I think if you look at the enumeration, anong section yun? By telephone, cellular phone, fax machine, or electronic mail, it's covered. Electronic mail. Ano yung sinasabi sa course? Yeah, but how do you communicate with each other? By email, di ba, in, hindi email, but you call, it's a communication that's electronic. It's an electronic communication anyway. So, I think that should be covered. Ang dami na kasi, di ba? Ang daming forms of communication. But I think when pagka nag-enumerate, hindi naman to ano ba yung rule of ELIA? If there's an enumeration, then it should be yun lang. But only if the law is, hindi ba pagka, kahit na non penal law, or can you say that if the enumeration is telephone, cellular phone, fax machine, electronic mail, does that mean and others like it? Diba? Hindi, unclear eh. Unclear kung kasama. Pero ako, if you ask my opinion, I think kasama siya. It qualifies as an electronic mail or communication. Kasi unfair naman, porque, diba?
Kasi 1997 ba? 1995 pa kasi. 1995,
The CSC resolution was issued 2001. Yes. RA 7877 is 1995.
I have a question po. You mentioned earlier that may certain, I guess you can call it biases, di ba, dun sa law natin. Kasi, for example, yun nga yung joke na may sexual undertones, yung ogling, for example, mahirap siya i-prove. So, how do we give justice to that kind of sexual harassment kung mahirap siya i-prove that it indeed happened? Ano po yung mga, meron po ba kayong mga parang examples na meron pa rin namang na-achieve na some form of justice for the victim kahit medyo mahirap nga i-prove yung case niya?
It's a private act. Usually it involves two people. Kagaya nung case ng ni Magat tsaka ni sino yan? Si
Formantes.
yung boss nung Medrep. Wala naman nandun, 'di ba? So it's really the word of one against the other. But as I said, yun nga yung pinoint out ko dun sa case, no? Parang usually the courts take the testimony of the offended, no? Gives it more weight. Kasi nga sinasabi nila, hindi ka naman pupunta sa korte at go through all that trouble para magsinungaling lang. Malay mo. Anyway, so that's the reality of it. No? Yes, it's hard to prove, but one, the easiest would be if you have a witness, kagaya ng case na sinabi ko, yung estudyante, may nakakita ng isang estudyante, so ginamit nila yung testimony niya. But essentially, if there's no witness, there's no camera, kaya dapat sa mga government offices ngayon, at least may mga, ang tawag dyan? CCTV, ganyan. So it's easier to check, diba? Hindi lang to check, it prevents. It's more preventive eh. Kasi alam mo may camera, hindi mo siguro gagawin. Tapos siguro yung emails, I think, I'm not sure what the policy of UPOU is with respect to emails of employees. Who owns it? This is a legal question, no? Who owns the emails? Essentially, if you're using the ang tawag dyan, yung hardware ng office mo, hindi ba dapat may karapatan ng UPOU na tingnan yon? Means, merong kaso yan eh. I think did you study that case on, there's a case na tiningnan nila yung emails ng mga empleyado, sabi ng mga empleyado, hacking yan. So, sinu nila yung employer nila. Yeah, but that's not our concern. Our concern is how do you make it easy for someone to prove there's been sexual harassment. So, you can emails, if it's done through that, or telephone conversations, or text, it can easily be proven kasi meron kang written or meron kang express proof. Yung mga acts na kayong dalawa lang nandun, wala na. Testimony mo na again. So it's circumstantial. Which one should be given more weight will depend on how well and how consistent or believable your testimony is, di ba? Kasi pwede niyang i-counter. Sabi niya, wala naman ako niya ng oras na yan eh. O, wala na kahit ano pa yung sinabi mo. So may mga ganon. But yeah, essentially you're right. It's difficult to prove because it's a private offense.
I will ask on her behalf. Pwede po bang magkaso ng matagal lang nangyari? At gaano katagal yung matawag doon, retro nung legal term for prescription?
Wala pa akong sagot eh.
Ay, ma'am, sige lang.
I know I saw a prescription here. I'm not sure if you saw it. Did you see it? Or wala? Am I wrong? May prescription kung kailan i-file. Although kasi, ang meron lang yung 15 days na kailangan immediately. Pag ni-report sa'yo, you have 15 days to act on it. Kung hindi, neglect of duty ka. So, we should be mindful of that, especially dun sa gender committee. When you receive a complaint, whether or not you think it carries weight na papaniwalaan nyo or it has probable cause, you You have to reply to him within 15 days. Actually, yung hindi na kailangan yung rule na yun kasi anyone who complains to a government office, di ba, were required under a executive, ano yata yun, administrative order ng president before na 15 days you have to reply. That's the, ano, prescription. If you're, ewan ko, sagutin mo nga, Miss Ophelia. Parang alam ko may nakita akong prescription. Can I just look for, wait lang ha.
Baka po may tanong pa tayo.
Penalties under Section 7. Any action arising from the violation of the provisions of this Act shall prescribe in 3 years. Tama ako. Can you check Section 7? Penalties. You don't have a copy of it, of the law? Anyway, yun. Section 7, any action arising from the violation of the provisions of the Act shall prescribe in 3 years. So kung meron kang iko-complain, dapat from the time it happened, 3 years yung prescription. That's under the Republic Act.
3 years. You have 3 years to ponder if magko-complain or hindi. Sige po, magtatanong pa po yung iba.
Just a matter of interest lang po. Ganun din po ba sa rape cases or is this for sexual harassment only?
Pero usually yung offenses, iba-iba yung prescription, di ba? Iba-iba yung prescription. For sexual harassment, it's 3 years under a special law, which is the Republic Act 7877. Rape, that's under revised penal code. May mga prescription yan. Ano bang prescription? Miss Ophelia, dapat alam mo yan. 4th year, question. Iba-iba. Meron mga 6 years, ganyan. No? So, I will email you the answer to your question when I check the revised penal code. Sorry, hindi ako litigation. So, corporate ako eh. So, hindi ko alam yan.
Habang wala pa ulit nagtanong. Uy, magtanong kayo. Baka sabihin, minomonopolize namin yung pagtatanong. May mga ano lang kasi nangungulit sa isip namin. Kunyari, yung binabanggit kanina, kunyari jokingly, yung mga jokes, kunyari, masyadong green-minded. Kunyari ako. Huwag ka na ilalayo, di ba? Masyado akong green-minded. And then I keep on telling such stories. Tapos, paano masasabi na nung kunyari, ano ba, kailangan ma-offend yung kausap ko? Or kailangan may work and education? Di ba may ganun? Kasi kung sexual harassment siya. May favor? Ganun ba yun? Nalito lang ako. Or basta nasa work premises or education premises, kahit walang work or education favor, sexual harassment na rin. Sorry, pa-clarify ito. Thank you.
In relation to that, hindi kailangan ng yung specific result. For as long as it's results in a hostile, offensive environment, it may already be considered a sexual harassment act. Kung mapapansin nyo, RA 7877, nakatatlo yung enumeration niya. So papasok tayo dun sa last, wherein there is a hostile and offensive environment against a person. Dun siya papasok. Especially in cases of kapag administrative yung tinitingnan natin aside. Kasi the CSC resolution and UP's rules and regulations, meron tayong specific enumeration of certain acts. Yes. So yung first yon, there's 1 and then 2 and 3.
Kasi we are gumagawa kami ng storya. Pwede mo kasuhan ang mas mababa sa iyong imposition kasi nakalagay sa UP rules lang co-employee. Sorry. Nada.
One of the main things no, that the UP rules added, may peer-to-peer. Okay. May peer-to-peer, so faculty to faculty, student to student, ganyan. Tapos nagdagdag sila na student harassing, right, a faculty and an employee. So pwede kung estudyante ka, only in those in that context na if you're a student, you're harassing a faculty, kunyari gusto mong maging honor, harass mo siya sexually under those tapos meron pa isa. Pwedeng kasi ang hindi kinlarify sa RA 7877 tsaka dun sa Civil Service Resolution, but in the UP rules it said it can be same sex. So pwedeng hindi ang sexual harassment nangyayari lang sa babae at lalaki. Pwedeng babae-babae, lalaki-lalaki. So yun yung dinagdag doon. So pwede, in answer to your question. Bakit? Ikwento mo na kasi. Ano ba yan?
Kasi faculty ako and then staff siya. Niregaluhan nila ako ng something. Pero syempre hindi naman ako na-offend. Imbento ko lang yun. Pero just in case na-offend ako. So I can sue or I can file a case against them. Talaga nakuturo ako sa kanila. Yeah, okay. Pero hindi ako na-feel offended. Yun eh. Oo, pero just in case.
Ano yung may sisterhood yun eh, yung parang mga magmamadre, pero hindi sila madre. Ano nga yun? Mga, alam niyo yun? Ha? Oo, ano? Ano? Parang mga hindi, mga madre na yan eh. But so, I was in a law firm before and I had an older lawyer, no? Babae siya. Na hindi namin alam, member pala siya ng Opus Dei, parang Opus Dei yata. May mga babae doon, di ba? Na we had to ride a car and go somewhere at the end of the hearing. So, nandun kami upo kami, mas matanda siya sa amin, so parang mas boss namin siya. So, yung isang lawyer, yun yung nagda-drive. So, nilagay, lalaki. So, we made the front seat vacant for her. Para wala siyang katabi. We're thinking, kasi ayaw niya na nasisikipan siya. So, kaming mga batang abogado pa lang, parang first year lawyer lang ako na, nagsiksikan kami sa likod. Ayaw niya sumakay. At naggalit siya. Hindi kami umaalis. Hindi naman namin alam na galit siya. Parang masama yung loob niya. Sumakay na rin siya kasi nagmamadali kami. In the end, she explained that it's their rule down that they can't sit beside another man. Parang ganyan. And it's, if somebody forces them, it's sexual harassment. Parang kami, ganun. So, my point is this, no? Ang levels of being offended is different for everyone. So, for someone, you say, ako hindi, birthday ko, regaluhan nila ako ng cake na shape ng boobs. Ganyan, no? Offend ba ako? Hindi naman siguro, diba? If it's all I would take it in spirit of fun. Pero iba-iba yung tao, yung levels of comfort nila with respect to sexual jokes, to mga undertones na yan, iba-iba. So hindi natin masabi. So this law actually makes it easy for someone nga to abuse it intentionally or it gives them an avenue. Kagaya dun sa, yung Opus Dei, may avenue siya now to impose that obligation na hindi ako pwedeng umupo ng katabi ng lalaki. So, it's a case-to-case basis. So, it's a case-to-case basis. So, yun. But, yes, it's very easy to file a sexual harassment case. Yun yung sagot doon.
Curious lang po, I don't know if natakal kanina earlier. What if I'm a third party and I feel parang harassed for another person? Say for example, may guy na joke si ate or whoever, and then I feel harassed for her. Can I file against a case against dun sa guy? Hindi naman ako directly yung inaano niya, binabasa or whatever. Pero I feel harassed for the woman.
Um, Personally, kasi if you read the rules and regulations, RA 7877 and CLSC in its strictest form, you must be the offended party. So you must be directly affected, you must be the direct person who was sexually harassed. Which means that um, na under these rules, no. Personal take, I don't think you may file, you can try, but the decision probably won't be in your favor. On the other hand, misconduct for example, of that person is a different matter altogether. So, what I'm saying is that siguro under RA 7877, CSU resolution, and and the rules and regulations of the university, hindi siya dun pwede, but not for other kinds of conduct in relation to what he or she or that person did.
Ma'am, how much would it usually cost? If we are to file a case for sexual harassment against someone, how much would it oh in the whole thing?
What do you mean filing fees? Are we talking about that? I'm not sure about administrative cases. Probably if you hire a lawyer, magmamahal siya, depending on the rate. Kanya-kanya kasing rate ang lawyers eh. Same thing with civil and criminal cases. Now, there's a difference for civil cases if you're asking for a certain amount of damage. Dun na depende yung filing fees sa courts. For criminal cases, kung walang ka namang hihingi na damages, although meron yan usually kasama, you can actually just file a complaint with the prosecutor, tas dire-diretso na yon. I'm not sure, but of course, usually people, even if those, although in criminal cases, meron ka kasing lawyer dyan na designated eh. If you're the complainant, you already have the public prosecutor. So if you hire another lawyer as a private prosecutor, of course you have to pay the lawyer his or her rates. But you can opt not to have a private prosecutor and instead just yung public prosecutor na lang. That's for criminal cases. But for civil, it's all you. Parang filing fees with the court, depending on the amount of on the amount of damages that you're claiming, including the rates of the lawyers. Yeah.
Susuglan dun sa tanong. So kung public prosecutor ang kinuha mo at hindi, so walang bayad yun, no? Tama
Wala
ba?
siyang bayad.
Tapos kapag ipinasok mo sa UP, kunyari sa OWASH ka nag-file, you don't need to hire a private lawyer also? Kasi tama ba? I-hear naman na nila yon.
Yeah. Sa rules and regulations, it does not state that you need a representative. You may have a representative, but not necessarily.
Okay.
If you can remember, the in relation to the formal procedure, all you need is a complaint which you sworn to, with or without your affidavits, and that is enough to file a complaint.
Oh, okay. And then gugulong na yung kaso doon.
Yes.
Magkano yung kung magsasettle na lang ng case doon sa nang harass, yung na-harass, magkano yung pwede niya, yung maximum na hingin niya? Kung gusto nilang isettle yung case na yun. Hindi ka ba settlement? Depende ba yun sa nagawang harassment sa'yo?
Okay, ganito yun, no? Usually, when you settle things amicably, para siyang negotiation. Bibigay ka ng price mo, bibigay siya ng price niya. And then, ganun siya mangyayari. So, when you file your case, there's a fine, di ba? If you remember, there's a fine under 7877, a certain amount of money. So, kung ipupush mo siya to the highest amount, and then hihilahin ka niya, parang negotiation nga yan, hihilahin ka niya na to settle on this amount. Now, that would depend on you kung papayag ka or hindi. So, if you agree, sige, fine, ganyan na lang na amount, let's just settle this thing, then okay. Or criminal. Yes.
It's not anymore just between the two individuals. Pag na-file mo na yung case, it takes a life of its own, especially if it's a criminal case. Kaya nga ang tawag sa criminal case, people versus. Hindi na ikaw yon, hindi Rowena versus Ophelia. It's people. Bakit? Kasi crime is an offense against the people of the Philippines. So, pwedeng kahit mag-negotiate kayo, kung gusto nung prosecutor utuloy, wala kang magagawa. Okay. Also, I think there's a provision, ito na naman ako, parang meron ako nabasa na pag nag-file ka na ng admin case at nag-retract ka, I think kung merong sufficient evidence, the administration can proceed with the dismissal or suspension of the employee. Hanapin ko ulit pag nakita ko. Basahin ko sa inyo.
Mga boys, pwede ba kayong mag-file against girls? Or against your co-drivers? Pag-isipan niyo yan, kuya.
Section 12, letter D. Withdrawal of the complaint at any stage of the proceedings shall not preclude the committee, yung ano to ha, CSC resolution, from proceeding with the investigation where there is obvious truth or merit to the allegations in the complaint or where there's documentary or direct evidence that can prove the guilt of the person complained of. So, pwede pa rin ituloy.
Lalo na po sa mga kadarating lang. Although, of course, pwede kayo nag-webstream kanina. May bulong-bulungan? Mang Nalds? May gusto kong i-share? Naka-offend na ba ako sa'yo? Na-offend ba kita? Lisa? I-email na lang daw si attorney. Ayan si ma'am. Sige po.
Magtatanong lang po ako. Pag ba, halimbawa, nag-joke ako sa tapos nadala yung aking pag-joke sa naging admin, ganon. Tapos, ano ang mangyayari sa akin? Warning lang ba o pwede akong matanggal? Halimbawa, hindi ko naman sinasadya yung joke ko, nagkataon lang na, diba, minsan yung joke natin napapasarap ka sa pag-joke, parang gano'n. So, ano po yung mga gano'n? Mga stages niya, warning, babay na, o yung gano'n.
Okay. Yung penalties, administrative penalties are always dependent, no, po, from sa acts na ginawa nyo. Now, if there is a finding, as you can remember, there are 3 kinds. Kung saan pwedeng ma-cover yung act mo specifically. In terms, in relation to UP's rules and regulations, not the CSC resolution. First, the UP rules and regulations. Now, if the finding of the sexual harassment, if the recommendation of the hearing committee is that hindi naman siya talaga ganon, you can only be just reprimanded for the act, not necessarily dismissal agad. Dependent po yan sa acts na ginawa nyo. There are certain, if it would be considered as a grave misconduct on your part, then that would, then you may be imposed the dismissal outright from the first offense. But when it comes to other acts not considered as grave misconduct, hindi naman yan directly or diretso na sa dismissal.
Hi, follow up on that. Kasi 'di ba yung the institution will be the one to establish kung ano yung mga penalties. Do I have a say on that? Let's say gusto ko matanggal siya kasi do I have a say on that o wala? It's the institution talaga ang magde-decide. Gusto ko siya ipabitay or whatever.
Siguro masasabi natin that it's akin to a criminal case. Kung ano yung penalty na imposed for certain and specific acts, yun na yun. Okay? Parang the institution provided that the penalties for the certain acts are these. Abangan mo na lang siyang mag-commit ulit ng second offense at third offense. Then saka mo siya pa-dismiss. O bilang ka muna. First, file ka. Second, file ka ulit. Third, file ka. Dismiss na. Ganon. But in relation to mapapakialaman ba natin, may papakiusap ba? No, there are rules. Of course, we also have to take into consideration the right naman of the offender when it comes to those things. Parang, di naman ako dapat na-dismiss, ba't ako na-dismiss? So, ganon. So we are, especially because this is a penalty. So hindi tayo pwedeng magsabi lang na no, I want you like dismissed and out of my life. So hindi ganon. So we are when it comes to imposition of penalties, medyo strict tayo. If this is the act, this is the penalty, then this will be imposed.
Regarding ma'am sa UP rules, may provision ba dun sa UP rules natin na magpa-provide ng support ang UP kapag may or generally anong pwedeng ma-provide ng UP besides pag-hear nung administrative case? O lalo na kapag criminal, kapag yung nag-ano ka na ng criminal case outside of the system. Kung may
Kung
mapaprovide.
magpa-file ka ng
Or kahit yung within din, yung both scenarios.
Under the UP rules and regulations, as I stated before, there are two kinds of procedure. We have the informal and the formal procedure. Now, the formal procedure provides for formal investigation. The informal procedure, siguro mas doon papasok yung question mo. According to the UP rules and regulations, the university must provide support. Now, the question is, anong klaseng support? Unfortunately, hindi siya provided talaga nung rules and regulations itself. Na for example, if you file a criminal case, we will help you. Walang ganun na specific and explicit na sinabi ng rules and regulations. However, there is a provision na nagsasabi that the Sexual Harassment Office provides for the procedures dun sa informal part. Now, yung informal part, dun naman papasok yung counseling. So kung sabi ng SHO, sige, we're going to give counseling to the victims or the offended parties, this is your informal procedure, o siguro pagbabatin or whatever, pag-uusapin, without the need of a formal investigation. Now that is part na yan ng duties ng university under its own rules and regulations. But when it comes to specifically na sinabi nila na we're going to provide you with this, we'll help you with this, no explicit terms on that.
Again, thank you to our speakers. To award the certificates of appreciation, I'd like to call on our Program Development Associate, Fina Flor F. Thailand, and our speakers as well, Attorney Rowena S. Dicini and Maria Ofelia Leaño. Yes po. Allow me to read the certificate. The UPOU Committee on Gender Concerns presents the Certificate of Appreciation to Attorney Rowena S. Dicini and Maria Ofelia S. Leaño for serving as resource persons in the seminar on Anti-Sexual Harassment Act of 1995, UP's Rules and Procedures, given this 18th day of August 2014 at UPOU CCDL Los Baños, Laguna.
Okay, dahil ako ang magko-close, i-MC ko na ang sarili ko. Ayan, on behalf of the whole Committee on Gender Concerns, chaired by Dr. Melinda Lumanta, we would like to thank everyone for being here. Kahit yung mga nasa naka-web stream, kasi kanina pang umaga may mga nag-web stream na po sa atin, na yung kanilang mga comments ay nasa comment din sa Facebook. Nakakatuwa lang na may mga ganon. So hopefully, we will have more for to come. Sa mga susunod, we will be announcing soon. Yung pong binanggit ni Ma'am Mandy kanina, yung International Symposium on Women's Studies, sa September po yan. And then sa October or November, meron din po tayong Responsible Parenthood na may gender lens, plus yung online cyber safety for children and women. Baka po sa October and November, back-to-back po yan. So sana po makarating din po kayo uli. At salamat po sa buong committee for being here, for being part of the organizing team. So kung wala na po tayong tanong at gustong i-share, handa na po ang hapag para sa merienda. Marami po ulit salamat.